share some of my views. And one of the first presentation you mentioned about it's not criminal justice system which is existing, it's only a criminal system. Professor B.B. Pandey always used to say in the criminal procedure and the lectures that please remember this is not a criminal system, this is a criminal justice system. Similarly, Professor Bakshi always used to remind us when we speak about justice, we should also speak about injustice. That's the reason I thought let me look at the state law and torture, what is a criminal injustice system. This is memorably pointed out by Dostoevsky in Crime and Punishment. How much youth was interred here between these walls for no purpose? What great forces had perished in here to no avail? The most talents, the greatest strength perished here unnaturally, unlawfully, irrevocably. Who is to be blamed for this? This is what is this criminal injustice system where we have heard about from the two presentations. One of the study of these 200 cases in Maharashtra under the Unlawful Activities Prevention Act, particularly the arrest, detention and trials of the Muslims which are suspected to be involved in the terrorist activities, and also we have heard the presentation of Manisha on the functioning of these tribunals. Let me take I wanted in 3 parts to present some of my views which I have been working for more than 2 decades into this agonizing domain of custodial violence in India, and also have represented some of these cases as part of when I was working in the Andhra Pradesh Civil Liberties Committee in India with Bal Gopal. So I wanted 3 parts. First is looking at the context. What is the context of understanding the state law and torture in India? Then the second is, I think this is again a session where the second point I wanted to look at the combination of critical criminology with the activist criminology. There we have seen how the activists and those who are engaged in the research, these are the two. And then I move to the third is, what is a theory? How do we understand state law and the torture and in search of the theory? So this is what I am trying to look at through these PowerPoints. First to look at the agonizing domain of custodial violence and the state crime and the activist criminology. Understanding, analyzing state lawlessness. I'll briefly focus on custodial violence and extrajudicial executions and the state lawlessness in search of theory. 4 interesting articles. One is Professor B.B. Pandey in his, he says about lawmen's ways and policemen's ways. That's a confrontation between crime control model and due process model. And this another one is a Lokneet article, this her book on transnational torture in 2012, and Lokneetha, and then look at interesting study in 1993's Herbert Kerman on the social process facilitating torture. So these are some of the things I thought I'll just. Here again I wanted to borrow these ideas from another great Chilean American writer, Marjorie Agosin. Says about how do we understand the torture. We have to unmask the strategies of torture. One must visualize 2 images, the suffering open body exposed to the pain caused by the torturer and the intimacy of act of torture. This is what is important when we look at the suffering open body remains invisible due to lack of public scrutiny. In fact, the reality is what happens in this custodial institution is not open to public scrutiny. That makes these invisible some of these crimes, and this is torture is discreetly hidden away from the public view, and this results in the denial and dignity and destruction of the personality of the detainees, whether it is the police station, whether it's the prison, whether several joint interrogation centers in several parts of India, which are not open to public scrutiny, which really makes. And the trauma, in fact, arrest is a frightening experience. In fact, and arrest of a petty theft, you imagine, arrest of a terrorist or suspected terrorist, arrest of a left-wing extremist is a much more harrowing experience. So this a detainee undergoes a trauma, and from the beginning of the arrest, detention in the police station or any other custodial institutions, and some of the studies have pointed out that these phobic reactions, when a person enters into the police station, undergoes several phobic reactions, and sometimes unable to withstand that pressure may also result in easy death. And in that process of when a person detainee is under several phobic reactions and a trauma which a person detainee undergoes in the police stations or other custodial center, there is no food, there is no deprivation of sleep, and then and in that process, if a torture or infliction of a physical or mental pain is given, and that will result in the easy death. So I wanted you to understand the custodial trauma before you understand the state law and torture framework. This accused, and there's several interesting stories are circulated, particularly in the whether in the custodial deaths or encountered deaths, that accused or suspect is dead in mysterious circumstances, and the state circulates suicide and natural death. Somebody said if somebody wants to commit a suicide, why they have to select police station, as if there is no safer place outside the police station. So these are all these stories which are circulated, and this invisibility results in a lack of public scrutiny also. The tortured body becomes a silent voice and mute in suffering and pain, and if the victim survives, then he can or she can speak and bear the witness. In this process, if the victim dies, there is no one to speak for the dead and protect the living. That's the reality of the custodial trauma or a torture, which is an invisible crime in India. Second part, I do not want to go into much detail. Second part is an interesting two or several articles. I'll begin with, in the academic circles in the international level, the first time the use of the word state crime, in fact state organized crime with William Chambliss used in the American Society of Criminology presidential address in 1989. He spoke about state organized crime. Later on it is revised as a state crime. And then later on this has created an interest in the academic circles all over the world, in the United States and UK, to look into and examine the state crime. State crime entered into the academic research after Chambliss presidential address. Chambliss defined state crime as acts defined as criminal and committed by state officials in the pursuit of their job as representative of the state. Interesting, in 2015, this Belknap, again in the American Society of Criminology presidential address in 2015, defines activist criminologist as one of what is the definition given by Belknap is one of the criminologists engaging in social and or legal justice at individual, organizational and or policy levels, which goes beyond typical research, teaching and service. So this is what I wanted to look at in this domain of agonizing custodial violence. What we require is a critical criminology theory and activist criminology combining together to work for the law policy reform.
Anyway, I say more in attached this book.
Yeah.
About Chambliss.
Chambliss, yes.
Before Chambliss.
Before Chambliss, yes.
She said
yes. Before Chambliss, I'll come to the national, the Indian, in the Indian context, the 1969, 1970 onwards, the state crime, issues of state crime, human rights groups started, even before Professor Upendra Bakshi, state lawlessness in India. State lawlessness in India, this 1970s onward, this is Andhra Pradesh Civil Liberties Committee in Andhra Pradesh, Association of Protection of Democratic Rights from West Bengal, Committee for Protection of Democratic Rights from Maharashtra, and People's Union for Democratic Rights in Delhi, and People's Union for Civil Liberties. In fact, if you look at, these are the three particularly, Andhra Pradesh Civil Liberties Committee, Association for Protection of Democratic Rights, and Committee for Protection of Democratic Rights have been documenting since 1970 into all the custodial and extrajudicial executions in India. In that process, there were also targets of the state repression, and so this is the initial activist or human rights activist documentation about state lawlessness in India started way before William Chambliss. But William Chambliss, I said about the international level, that spotlight on state crime that has, and of course Professor Bakshi in the Crisis of the Indian Legal System, 2 chapters on police and the prisons have explained some of these dilemmas and crisis which is existing in India. And the human rights groups in India played a major role in critical activist criminologies and put a spotlight on state lawlessness. And Professor Muhammad Gauss in 1985, he wrote in India on state lawlessness and lockup deaths, and that also is a pioneering work which has resulted in some other works. Now let's look at, briefly, with the Protection of Human Rights Act in 1993, Government of India has set up the National Human Rights Commission. One of the advantage of the National Human Rights Commission is after 1993, at least there is some reliable official statistics are available to study the human rights violations committed by state, and they call as a custodial violence. So the National Human Rights Commission of India defines or classifies custodial violence into illegal detention and arrest, torture, custodial death and disappearance, and the custodial deaths are further classified into deaths in judicial custody, deaths in prison, and deaths in police custody. Judicial custody is deaths in prison, and deaths in police custody is the police custody deaths. And extrajudicial executions, which are colloquially called as encounter deaths, have been added into human rights violations of NHRC's the data in 1997. In 2003, they have added another category, the deaths in defense and paramilitary custody. So this is some classification of state lawlessness or custodial violence under the National Human Rights Commission, and every year annual report will give about some of these. And the last more than 93 to 2014 mentions about increasing deaths in the prison. I will not go into the details. Now I wanted to look at and discuss with you how we construct a theory to understand the state lawlessness. This is what the first one is, lawman's ways and policeman's ways. This is what in the students of criminal justice, criminal procedure, we start with this discussion. Crime control model, Herbert Packer, who has given us this crime control and due process model, and we start with the teaching of the criminal procedure with this. Professor Pandey says the lawman's ways is the due process model. The constitution says, procedure says, policeman's ways is this the crime control model. There is a constant conflict between crime control models. As Professor Pandey says, the human rights rhetoric hardly been able to transform the concrete reality due to this conflict between lawman's ways and policeman's ways. It's very interesting if you look at particularly the D.K. Basu, Joginder Kumar and Sheila Barse. 1983 to the D.K. Basu is a landmark in the custodial violence in the custodial justice, but entire discretion is available only to the police. So whether your Article 32, Article 226 and such warrant under the Criminal Procedure Code is completely meaningless unless the policeman decides to enter arrest into the station house day. So how do we do that? Interesting article, this John Hopkins University, Thomas Simon in 2015, he says, so far torture debate is, troubling thing in the torture debate is, they have focused all these years on the victim. We should shift the focus from victim to the perpetrator. Very interesting. What it matters is a state as a perpetrator which implements, and it is a policy. Second interesting is Loknitha book on transnational torture 2011 argues, this is a very interesting argument, I think some of these issues have come in this panel. Torture is a manifestation of loss, tension with violence, and it is continually accommodated and negotiated within the law itself as exemplified by the jurisprudence of interrogation in both India and United States. We have seen how these torture happens, whether from the arrest, detention, and during interrogation, and even the post-interrogation what we have seen. So this violence is produced and legitimized by procedure, policies and practices. That's the reason I would prefer to call as a criminal injustice system. And the denial of torture and lack of public debate, this is again Loknitha says, the denial of torture and lack of public debate on it relegates it down to the problem of policing only at the lower levels. This is an interesting study of Herbert Kerman in 1993, who identifies three processes, the social processes facilitating torture. He says the three key concepts: authorization, routinization and dehumanization. If you say that Bhagalpur, these are the professional thieves, or so and so is a suspected dangerous terrorist, Islamic militant, then you say you justify, authorize that though you have a separate preventive detention, you have unlawful activities prevention, they can be tortured, confession is granted, so you are authorizing by the procedure and other. Once it is authorized, it has become a routinization. You have created some of these special task forces and special police, those who are bloodthirsty policemen. And then once it becomes that process, this is dehumanizes a person. In fact, one of the police officers recently in the Orissa of the discussion, he was saying there's a completely change. When daughter has pointed out, when he was a young police officer, he was like this, but in the process after 5 years, when due to the daughter's influence, daughter started interrogating him, and then there's a complete change in his attitude and perception, and he's a completely different man. He mentioned about in one of the. So the justification of torture as a means of protecting the state against threats to its security helps to authorize the practice. The development of a profession of torturers as part of state's security apparatus helps to routinize the administration of torture, and the designation of torture, targets of torture as enemies of the states are excluded from the state protection and helps to dehumanize. Lastly, I'll end with this. I was just sharing yesterday about this German jurist, Gunther Jacobs, in that book on insecurity states, Peter Ramsey, 2012. He mentions about this Gunther Jacobs, who proposed that much of the contemporary criminal law can be characterized as enemy criminal law, a legal form that contrasts with citizen criminal law. In the enemy criminal law, the punishment precedes harm, resulting in suppression of procedural rights. The reverse is citizens' criminal law. It separates dangerous from law-abiding and advocates punishment proportionate to crime. Thank you.
And then